Welcome, and depending on where you're located, either good morning or good afternoon. My name is Alex Brackett. I'm a partner in the white collar litigation group with McGuire Woods, based in our Richmond office. I'd like to welcome you to this panel discussion on handling internal and external investigations in the current pandemic environment. I'm going to be your moderator today. We have a wonderful group of participants. A little bit about myself. My practice is a broad white-collar practice, including experience conducting internal investigations and defending external across the full spectrum of white-collar needs and industry clients. Just to let you guys know a little bit about where the idea for this came from, we conceived of this panel primarily as an opportunity to invite clients into an iterative dialogue amongst partners from our labor and employment and government investigations practice groups to talk about things we are and things we are not seeing right now in terms of the conduct of internal and external investigations in the current environment. In putting the panel together, we wanted to have a good cross-section of these departments, which often work in close collaboration and which have strongly complementary views of the current investigation environment for our clients. Our goal is to share some of the perspective of our participants, hopefully field some good questions from the audience, and for us all to leave this time together with some new insights and some strategies for navigating the near short term as we begin to reopen the economy and reset our investigative norms. I do want to encourage the participants to submit questions. We're probably going to save those for the end. There's a Q&A tab that should be on your screen, and you can submit your questions there. I'd now like to briefly introduce our panel. First is Peter Farley. Peter is a partner in the Labor and Employment Department with a diverse litigation background, representing clients across a variety of industries, issues, and forums. His practice regularly involves internal investigations and engagement with external authorities. Peter's based in our Richmond office. Next, I'd like to introduce David Greenspan. David is also a partner in our L&E department with a similar breadth of experience, including extensive work on the defense side of labor and employment issues. David is based in our Tyson's office. Matt Orso is a partner in our government investigations department who regularly companies facing government and regulatory enforcement investigations. He's conducted internal investigations for the country's largest financial institutions on topics including regulatory violations, BSA, AML issues, employee misconduct, and whistleblower matters. Matt is based in our Charlotte office. Francesca Titus is a new partner in our government investigations department. She represents companies and individuals in complex, high-value, multi-jurisdictional, white-collar criminal litigation. Her cross-border practice includes advising clients from across Europe on high-profile investigation matters. Francesca is based in our London office. And finally, Molly White. Molly is a partner in the government investigations group as well. She was previously a prosecutor with the SEC and now serves as co-chair of both the FinTech practice group and the Securities Enforcement and Litigation group of McGuire Woods. Molly is based in our LA office. So to kick us off, in this era that we're in right now, every action that can have an effect on consumers is going to draw close scrutiny by regulators of all stripes. I'd like to get the panelists' views on some practical ways to analyze these risks and take steps on the front end to mitigate them. Things of in response to hotline reports, mining data from customer service interactions, coordinating with regulators. Molly, do you want to take that up first?
Sure, I'd be happy to. So given these unprecedented times, both in terms of the stay-at-home orders and the market volatility, I think it's fair to say that regulators across the board are on heightened alert and trying to ferret out misconduct. like a lot of other regulators, the SEC has announced that it has a coronavirus steering committee that is focused on emerging risks and challenges in the COVID-19 era. So I think, it's fair to say that we can all expect some regulatory scrutiny down the line. And when that happens, we want to make sure companies are going to want to make sure that they can make clear that they're some of the good guys, right? That they've been doing what they should do. So what can you do to sort of anticipate what we expect to be some heightened regulatory scrutiny? Obviously, there are policies and procedures in place, and it's important that companies continue to follow their policies and procedures. And doing so now more than ever, you want to make sure that you are escalating issues and addressing them quickly, since time can be your enemy. Another important thing, I think, is to document, right? So not only as issues arise, should they be escalated and addressed, but be sure that you're taking steps to keep track of what has been done. Again, when the regulators or others come knocking on your door months from now, you want to be prepared. And obviously, if you do find a bad actor at your company, you need to address it quickly and consider reaching out to regulators to address the issue. I would also say that this is probably a good time to review your business continuity plans. I know that these are unprecedented times with most of the workforce working remotely. But now that this has happened, it might be a good idea to think about this happening again in the future and be prepared. So those are some thoughts that I have for addressing the onslaught of regulations or regulatory inquiry that I think will come.
Thanks, Molly. David, let's look at that same question through more of an L&E lens. How does this translate in the environment you're typically working in? And in particular, are there things that, HR and hotline monitoring teams want to be keying into?
Sure. I mean, at a high level and in many respects, the scope and content of employment investigations is relatively unchanged. Employment matters typically focus on violations of company policy as a threshold gatekeeping matter. And particularly where the fact finder is not a lawyer, we want to make sure that we're substantiating or unsubstantiating facts or policy violations and not getting to legal conclusions as a general rule. In the COVID-19 world, we're starting to see what I think is kind of the beginning of several new theories of claims and liabilities and ways that employees are presenting issues to their employers. We're also, I think, starting to see certain state and federal agencies, EEOC in particular, and OSHA in some regards, starting to come back into their virtual offices and kind of, administer the federal and state statutes. I think the key, and this is a theme I suspect you're going to hear from all of us, is don't wait, follow the corporate policies and guidelines that are in place, take advantage of the technologies that are available to, the particular employer. And my last comment would be, keep an eye out for COVID-19 related issues, because I think not only are there legal consequences from an employment standpoint, I think there's a PR consequence as well for not managing or handling things that need to be investigated. The key for me, the one that's coming up most frequently, are requests for accommodation. People that say, I'm in a compromised class, I'm high risk, but it's not because of a disability or an impairment necessarily, it's because of caring for another. And when they take issue with how an employer handles that, that in and of itself could be an ADA accommodation issue that some employers are not quite picking up on yet. Great.
And, one thing that I know I've seen with a number of clients recently is a real heightened sensitivity to whistleblower issues. And Francesca, I know that's something that you and I've talked about before. So do you want to add anything in here on sort of the handling of whistleblower issues and whether that's any different or whether the sensitivity is truly any heightened right now, or just give us your view on that?
Thanks, Alex. So good practice of course, requires having protocols in place for whistleblowers, but these really need to be tailored to the jurisdiction in which any corporate has got operations. So the protection for whistleblowers varies so significantly from country to country, even across the European Union. So currently only 10 countries in the EU have got comprehensive laws protecting whistleblowers, but the EU are trying to combat that with the new whistleblowing protection rules, but those are not going to be enforced until December 2021. So we are seeing with COVID a large increase in whistleblowers, but not really seeing a corresponding reaction from countries knowing how to deal with that. So the advice really for corporate clients is when you're dealing with whistleblowers, always make sure that you have a policy or protocol that is directed to the jurisdiction in which you have operations. And also have in mind, of course, whistleblowers' motivations. So in some jurisdictions, such as the United Kingdom, whistleblowers are not able to be paid by authorities, but they can be paid by the media. And often we see whistleblower reports where the motivation is really just media attention and a small amount of money from the press. So to summarize from me, I would say organizations need to ensure that they have policies for whistleblowers very much appropriate for the jurisdiction in which they're operating, and have in mind what the motivations of those whistleblowers might be.
Great. Thank you. Peter, I want to come back to you for a second to get your perspective on sort of what is or isn't different in your world right now. Because David certainly seemed to indicate that in a lot of respects, things haven't changed that much, so at least in the realm of labor and employment focused investigation. So can you sort of jump in on that and give me your perspective on what has or hasn't changed from a best practices perspective?
Thank you, Alex. Yes. So David is right. A lot of the investigations that we see on the labor and employment perspective or front are similar in substance in terms of whether we're looking at wrongful conduct, harassment, discrimination allegations, and what have you. The important thing to consider as you undertake an investigation or look at undertaking an investigation in this environment is how to adjust the process of how you're going to approach your fact-finding and making sure that you have your protocols, your procedures, your policies in place to deal with remote investigations, whether being done by telephone or video conference or a combination of that is important. So first, it would be important to the extent you have a policy on investigations or investigations or procedures are built into multiple policies. Evaluate those to make sure that your procedures can adapt to what you need to undertake in this environment by conducting them remotely and what have you. I would also suggest, consider maybe if the process itself should be changed a little bit. When you're talking to someone remotely, it's impossible without going through some extra steps to make sure that person is not accompanied by someone else, that you have the proper note-taking, et cetera. So those procedures, I think, are important to kind of revisit. On the substantive front, I would be on the lookout for creative retaliation claims. I mean, one of the things that we are concerned about and that we are advising clients on is to understand how COVID-19 has presented different employment problems and issues. And as we're investigating concerns, being mindful of what otherwise would not be considered retaliatory conduct arising to that level. The Family First Coronavirus Response Act has an anti-retaliation provision in it. So for smaller employers under 500 employees, that's one new retaliation aspect that we want to be careful about. But the retaliation protections in the other employment laws are as active as ever. And so as you're going through the investigative process and you're trying to adjust your procedures, regardless of what you're looking at, make sure that you're mindful that you're doing so in a fair, objective, and even way so that the process, the investigation itself, cannot become the focus of a potential claim.
Thanks, Peter. And Matt, I'll throw that same question to you from a government investigations perspective. What have you seen so far in terms of how this environment has impacted both how you conduct internal investigations and the level of activity that you've seen from an external government investigation perspective?
Thanks, Alex. I think this has kind of been a common theme already so far, but in terms of internal and we're calling them external investigations or government-facing investigations, I'd say. Not a lot has changed in terms of what we would consider the best practices for conducting those investigations, whether internal or external. What I mean by that is for external kind of government-facing types of investigations, it's still about getting to the bottom of the facts, right? Still about showing the government the good faith of the company, while in most cases doing everything we can to cooperate with the government and mitigate any fines or penalties. Those are always present in an investigation that's government facing, pre-COVID-19, during, and post-COVID-19. And from the internal side, it's similar, doing everything we can to determine those facts of what occurred, help guide the company in taking the proper steps to remedy any issues, whether they're customer harm related, employee misconduct related, as David and Peter were talking about. In both contexts, we're always wanting to still identify the root cause of any problem and address those issues that might come up with companies' policies, procedures, and controls. There are things that are different, though, and I think what's different from the practical standpoint is probably obvious. It's the hurdles that we encounter in actually taking the steps to conduct a proper investigation, taking the steps to still comply with company policy. At the beginning of the crisis, from a government perspective, I think we saw a brief slowdown in enforcement activity, very brief, at least in my experience here, as government agencies work to adapt to that new remote environment. But as of recent weeks, we've seen it pick right back up. Both investigations that had begun prior to the COVID-19 era, as well as significant interest by facets of the government related specifically to COVID-19 and the relief efforts, especially relating to funds and relief provided to customers, whether it's financial institutions, healthcare institutions, kind of across the board. I think it's really been a focus of state attorneys general, banking supervisors, and others to focus on how financial institutions have handled in the U.S. The CARES Act and the relief provided through that federal relief. In terms of what's changed for internal investigations, it's really the remote aspect of things. We're so used to being able to conduct investigation interviews in person. It's just a lot easier to have a conversation, and that conversation flows better when it's in person, but we obviously can't do that right now. And so it's about being able to adjust to conduct remote interviews, whether that's on the phone or through a video conference, those types of practical items, really.
Yeah, great, Matt. Thanks. Yeah, and I think I share your view and experience, and in particular, I'm paying a lot of attention to what some of these, cooperative state and federal task forces, what they're going to look like and how they're going to shake out in the coming weeks and months in terms of where they really start directing their focus in terms of, in particular, consumer protection type investigations. Francesca, we've been fairly U.S. centric so far, so I want to come back to you. Are there any trends that you've observed so far in Europe in terms of efforts to exploit the situation and investigative focus on the continent and in the UK?
Sure. So we have seen a big move by cyber criminals to target large organizations with COVID-19 related scams. So that's included phishing emails, malicious applications like ransomware. And the goal of these criminals has included espionage, data theft, commercial gain. Additionally, we're seeing a big rise here in Europe in insurance-related frauds, investment fraud, supply chain scams, and banking frauds. We've got our local UK law enforcement really working with colleagues from across the globe to help combat this. So recently, our UK National Cyber Security Centre issued a joint advisory statement with the US Department of Homeland Security, really focused on how COVID-19 is being exploited by malicious cyber actors and warning organisations about how to protect themselves. But as you would expect, the English don't just work with the UK, and we have really close cooperation with our European neighbours. And within the European Union, that cooperation normally happens through something called a joint investigation team, so the JIT regime. And that's where UK law enforcement teams work with other law enforcement from across Europe. And the JIT, the Joint Investigation Team, is governed by a written agreement between the parties to that team. And they will have established themselves to carry out a specific criminal investigation. So the thing as defence practitioners that we really need to note is that under the terms of a JIT, the countries participating can ignore the usual mutual legal assistance treaties. The terms of the agreement mean they can just share and exchange information, but also share evidence without needing to use the normal formalities. So this makes the exchange of information much smoother and much faster. So although here in the UK and Europe, we have really seen a spike in COVID-related crime, I think we can expect to see a very robust response from UK law enforcement, but working not just with our US counterparts, but also with other European law enforcement teams.
And what have you seen in terms of company responses so far? Been reevaluating risk profiles? Have they, been altering the way that they've, gone about their handling of these issues?
Yes. So in the UK, there has, unfortunately, for companies who, of course, are facing really unprecedented pressures at the moment, a clear message from regulators here in England that there is not going to be a compromise on their expectations of firms, and that firms still need to protect customers and shareholders' interests. So a good example of that, I think, is the Financial Conduct Authority, our equivalent of the SEC, who have been really very vocal about the need to be alert to financial crime risk. So companies are still having to reassess risk and then actively and appropriately manage it, because it's what's expected over here. And of course, there are many areas where risk has changed. So one that's affecting, I think, almost all organisations, and hopefully is useful to those watching this, is to do with remote working. So firms have had to rapidly deploy new networks to cater for the large shift to home working. And almost overnight, we're seeing an office infrastructure for many businesses changing from a single or a few office locations to hundreds, or if you're a large organisation, even thousands of virtual home working locations. And all of these are access points to your company's network. So, of course, that's a risk that needs to be reassessed. This all coincides with a time when payments are moving digitally, and at a time when staff are less closely supervised. So we are seeing a trend that where things would naturally have been picked up in an office environment, they can now slip through unnoticed as workers are dispersed across many, many locations. So companies, to prevent problems arising in this way, they need to be reviewing and updating their policies, but also making sure that those policies are actioned and implemented in the new environment that we are now all facing.
Great. Yeah. And that actually leads into my next question. And it's something that a couple of you have touched on in some of the answers that you've given. And that's that we've all become more accustomed to using video conferencing technology. We're using it right now. But it does lead to the natural question of how effective we'd be in conducting interviews remotely, and what are some of the hurdles we can anticipate and some of the strategies we can think about to overcome those. So I guess I'll turn back to Peter and David on this first. Do you guys want to give some views on your experience so far with the use of video conferencing for conducting investigative interviews?
Sure, Alex. You know, a live witness interview is always the gold standard, but I think in our collective experience as a group, we're finding that video conference technology does, you know, everything substantively that you need for the most part, with the limitations that we have. I think it's important to really focus on the prep aspect, not only of the scope of investigation, but also of each witness interview. This is something that, you know, necessarily is taught to those conducting investigations anyway, really prepping each interview, the documents that you need, the policies that are relevant, the witnesses that you need to speak with, ordering them. All of those tools of the trade are even more important to think about before you, I'd say, set foot in the room, but I guess, you know, plop down in front of your computer is the better way to say it. I think if we were to drill down just a little bit on this, you need to make the technology work for the situation that you have. Think about, for example, the security issues. I mean, what is the scope of the investigation or the subject that you're dealing with? Are there confidentiality issues? Are there security or clearance issues that you need to think about that you would normally not have to worry about if you were having an in-person conversation? Upjohn warnings. I mean, generally speaking, they're delivered and they're formalized and a person signs it right then and there. And here that obviously can't happen. So do we need to consider an email to the person, the subject of the interview, as a PDF that they open before the interview or during the interview, or do you follow up afterwards? You'll note that I'm not suggesting any one is the best practice. I think it really depends on the situation. The other thing that I would just flag as something to think about in terms of prep is recording. Each state has their own laws in terms of eavesdropping and surveillance, and video is distinguished from audio. And, you know, it's something to consider when you're using the technology, whether you should record, can record, need to disclose, whether you can be recorded by the individual, just thinking through those issues. And then the last high level thing I would comment before turning it over to Peter is, you know, the order of the witnesses matter even more because we don't have the control of the building or the facility. So when you say to a witness, don't talk to anybody else, you're not there, they're not there. So you really need to coordinate. If you need to talk to 4 people about the same issue, you may need to have multiple investigators ready to go at the same time to make sure that the subjects are not talking with each other. So those are my high level thoughts. Peter?
Yeah, thanks, David. And I'll just, in connection with that last comment, you may want to seriously consider how closely you talk to witnesses, talking to them possibly right after one another, very close, so that you avoid leaking information from the investigation as you're trying to go through it. It's easier to do that when you've got witnesses face to face, but if you're in a virtual environment, that can be a challenge. I think as you consider the need to do investigations in this environment, look to the policies or procedures to make sure you can do them this way, and think of the housekeeping items that we've been mentioning so that you comply with your procedures and policies when doing the investigation. Confidentiality is going to be a key, as David mentioned. When you're in the room with someone, it's pretty easy to determine who else is there, what confidentiality concerns you can protect against and ensure are in place. But in a video environment, it's very hard. I remember one of the first video depositions I ever did years ago, and I could see the opposing counsel's hand coming into the screen every now and then, trying to direct the witness. And it made for an awkward discussion with that person when I called him out on it. But the issue really is very present today as we try to engage in this very important exercise of an internal investigation, regardless of the subject matter. How can we ensure that the sanctity of that investigation and the process will be followed and will be adhered to by all involved? Another best practice that I think is something to consider as you're doing a virtual investigation is how you're going to show documents, evidence, information that you may have in your possession to a witness, confront that witness with it, ask them about it, try to get their information and their perspective on it. It's very difficult to kind of send things in advance. It's not really probably the best way to go. Think about technology and ways to publish a document to a witness, either via a shared screen or some type of other technology that exists that enables you to do a thorough review with that person without having to compile everything ahead of time and try to get it to, the witness before you're talking to them. And then also I would just underscore one of the things about, upjohn warnings and what have you is making sure employees acknowledge to the best you can in writing that they're going to comply with procedures, they understand, you represent the company, et cetera. And doing so via email or via some kind of a certification or acknowledgement. And if it has to happen, if it's after the interview, following up on that is important. It's always better to do it ahead of time. But as the practical limitations of conducting an internal investigation in this environment constrain your normal procedures, make sure you think through some of these very important housekeeping items so that you conduct a thorough investigation and the company can rely on that information as it begins to evaluate making decisions with respect to what you find.
Great. Molly and Matt, I want to get you guys to weigh in on that same issue because obviously the posture can be a little bit different when you've got a government regulator on the other side, DOJ, SEC, what have you. So what are you guys seeing and hearing right now in terms of concerns about willingness to engage in, video conference, witness interviews and that kind of posture with a government investigation?
Sure, I'll jump in here. I think, first of all of those considerations that Peter and David just discussed come into play when you're considering giving video testimony with the government. There's been a lot of conversation about this among those in the SEC defense bar. I think, as most people know, the SEC was ordered to work from home on March 10th, and those stay-at-home orders are in place through July 15th. So that has meant that the SEC staff has had to switch to virtual testimony or video testimony. And in March, the SEC Director of Enforcement announced that basically staff would work with lawyers in the defense bar. I think that a lot of our defense counsel have felt very hesitant to offer their clients up for video testimony. Some of the concerns are obviously that if you're not in the room with your client when you are defending testimony, are you going to be able to pick up on nonverbal cues, for example, when your witness looks uncertain about an answer? And I think there are also a lot of concerns about how do I, pull my client aside and have a conversation or consult with them. So given some of these concerns, there has been a varying amount of resistance among the SEC defense bar. I've seen a lot of things. I mean, basically, it's evolved into a lot of negotiation, right, about whether video testimony will take place, whether we'll just postpone testimony altogether. Some lawyers have gone in and have done attorney proffers in lieu of testimony. And I think that the SEC staff has been pretty willing to work with the defense bar. Quite frankly, don't think they have much choice since SEC testimony subpoenas are administrative subpoenas. And if the SEC really wants to force video testimony, they're going to have to go into court and go forward with a subpoena enforcement proceeding, which is a difficult thing to do when so many of our courts are basically shut down. We've seen varying responses. I've also heard situations, though, where people in the defense bar have decided to go on the offensive. I'm aware of a situation, for example, where somebody's actually in active litigation with the SEC, and they opted to go forward with in-person testimony in Nevada, where that's permissible. And the staff, of course, objected that they could only attend virtually. So it's definitely generated a lot of discussion. I think that the upshot is if you do have the SEC reach out and want to take video testimony, I think there are a lot of points to negotiate, and ultimately you have to decide what works best for your client in that specific instance.
Matt, you want to jump in?
Absolutely. Thanks, Alex. I think a lot of what the panel has already discussed in terms of David and Peter especially got me thinking about the focus on employee interviews as part of an investigation, how it's such a critical part of any investigation is interviewing individuals, whether they're witnesses or someone who's the subject of allegations. But that's certainly not the only piece. And so I think it also forces us to make sure that we are also diligent about gathering every other piece of potential evidence that might be relevant to the issues, that we're not missing some database within a company that might store relevant documents. In the end, witness interviews are important, but they're not the only piece of evidence, and we need to use other evidence to corroborate or rebut that witness's testimony anyway. So I think it's forced us to be a little more, potentially more diligent in ensuring other information doesn't go missed. Another thing that I was thinking about when the panel was speaking is mobile devices. That's one thing that often want to image in the context of an investigation, an employee's company-issued mobile device. When people are working remotely and in this pandemic era, often we just won't have the ability to do that. And so that provides another hurdle. But I think the general theme for me is, although it's not business as usual for any company out there right now, we need to conduct investigations as if it was business as usual. We've still got to take all the same types of proper steps in being diligent. In terms of online and remote interviews, I think there are some unique situations that David and Peter mentioned as far as online platforms for conducting video conferencing interviews, or at least for sharing documents if an interview is being conducted over the phone even. Sequencing is extremely important, as was mentioned. Also, just having a master of whatever platform you're using is extremely important. If you've got, it was mentioned before that you might want to squeeze together and sequence a number of witness interviews all in a row so that people aren't able to talk to one another in between, or at least to avoid that or to mitigate that. So if you're doing that and you're using the same web platform for each of those interviews, one after another, you've got to make sure that you set it so that you have to admit attendees as opposed to anybody being able to enter the room at any time, right? You don't want the next person in line to come in 5 minutes early and be able to see the end of the interview that's happening right now. Just those kind of technical, logistical things that you need to be diligent about. Another basic thing is, but that I think people forget to do sometimes, is to end the meeting when it's over, to stop sharing your screen when the interview's over. So many hazards can occur that way. You pull up an email from another client that's privileged. You pull up another record from that same investigation that you didn't want that witness to see, and now they're looking at it on your screen because you forgot to click end meeting. Little things that are, I think, obvious, but that are easy to forget in the moment, in the kind of tension and hecticness of bunch of interviews conducted right in a row. So I think hyper awareness and diligence are really the things that are required in this environment.
Yeah, great. Yeah, I agree with everything that everybody's been talking about, and it raises some real questions in my mind too about as we start to reopen the economy. We're all in sort of a remote posture right now, and we don't know exactly what things are going to look like going forward. We know they're going to look different, and it reminds me of one of our colleagues who actually early in the pandemic, before everything was fully shut down, they've got a big investigation going, and the U.S. Attorney's Office and FBI agents involved in that one rattled their sabers a bit and refused to do remote interviews, said we've got to do these interviews face to face, and there's not a travel restriction right now. The client agreed, and a week after the interview, our colleague got a notice that the FBI agent who was pushing the hardest for an in-person interview tested positive for COVID. So everybody who participated had to quarantine for 2 weeks. And, that's, just one example of some of the challenges that I think we're going to see as we do start to reopen, and I think that we could also end up seeing sort of a hybrid working model in the not too distant future, where there are some people who are going back to work and back to offices. There are some people who are still remote, and some people who are saying, I'm going to work remotely until there's a vaccine. And so that, I think that raises some interesting questions around what investigations start to look like, particularly as we get back into a posture where there is more comfort doing face-to-face interviews. But it also raises the question in my mind that I want to open this up to the group of what kind of issues can that present? For example, how do we manage if there's an employee who we think is sort of gaming the system to avoid scrutiny or avoid having to sit for an interview? How do we weigh that against legitimate concerns that people might have because of an underlying condition? You spoke to it a little bit, the document and data control and our concerns for managing risks around things like cybersecurity, because the more that we're engaged in these kinds of discussions over an electronic platform, the more risk that we've got that there's going to be some kind of breach. So, Peter and David, I'll start with you guys. I mean, this, particularly as we start to reopen, we could end up in some sort of tricky territory from an L&E perspective. Sort of agree or disagree?
Thanks, Alex. This is Peter, and I'll start with that. Yeah, I definitely agree with that. The issues over employees returning to work or dealing with being remote and what that means to his or her employment as they try to manage that is a significant concern. The golden rule in investigations, right, is to make sure you conduct the investigation, you prepare the report in a way that if it's published or used, you're going to be completely comfortable with how and what's said in that. And I think that the approach for conducting investigations in this current environment is one where you need to really remember that golden rule. How you do the investigation, how you interact with the employee, how you're requiring and requesting, and I say both of those on purpose, requiring and requesting their cooperation is really important, because again, without the in-person involvement, you lose some of the intangibles that you gain from doing an in-person investigation. We've mentioned it several times during our discussion, but I would say here it's important to really look at your written policies and procedures that deal with investigations and make sure what you need to be doing for today's environment is in there. And if not, try to revise those policies so that you can include that kind of flexibility for this kind of an investigation. I think it's very important that you stress to employees ahead of time and during the investigation that their cooperation is important. It's necessary for the company to uncover the facts associated with whatever the allegations are, and that all the regular policies and procedures related to their employment apply, even though they may be in a remote environment. I think it's also important to be sensitive to the anxiety employees are going to face in dealing with an investigation and an investigation that's being handled remotely. Employees will be expressing concerns about that. They may have confidentiality and privacy concerns of their own. So you want to be prepared to evaluate that, address it, provide the appropriate level of assurance without going, too far. In addition, I think, and David will touch on this next, but be mindful of document retention, document gathering, and how you're going to do that. And with that, I'll pass it off to David to touch on some of the key things to consider along those lines.
Yeah, let me just back up a step, because Alex's question, when I heard the framing of the question, it kind of struck me that, litigation is defensive, investigations, it's a hybrid of a little bit of proactive and reactive employment work. But Peter hit the nail on the head. This is a very uncertain time, and there are a lot of really good employees who are ready to get back to the office or their work environment. And there's a lot of really good people and employees who are not quite there yet for lots of good reasons. Some are legally protected, some are not necessarily protected, but completely valid. So I think this comment is probably broader than just conducting investigations, although it rings true, is, making sure there's a good corporate ethos and a practicality about how you handle these situations when people bring in concerns or issues, I think is worth its weight in gold, and probably greatly reduces the number of formal complaints that you get in the door through the hotline or through HR or through Ethics Point. Very, very briefly, just in terms of the document retention, because Peter flagged that as kind of the comment that I would have for you. I really think it goes back to planning. It's even more important to understand what the technologies that your corporate entity has, or if you're guiding a company. A lot of businesses are now going to cloud-based technology, and it really makes it difficult, in my opinion, to preserve documentation. Never mind litigation holds or preservation issues, which need to be considered in any investigation, but just getting your arms around what's out there. I think it's, at least for me as a lawyer who, I don't hold myself out as an IT guru, but I need to understand where the documents are maintained, servers, computers, phones, different technologies and tablets. It's even more important in this environment to either have that conversation with your business client so that you can have it with the corporate witness. And if you don't know how to ask the right questions, consider talking to the IT people who are an invaluable resource when it comes to identifying where all the documents and data that you need are actually hidden.
And I'll just jump in from the government investigations perspective. I know that it was mentioned we certainly need to be careful of the anxiety of individuals who might be frightened because of the pandemic, who are working from home, whether they're immune compromised or not. At the same time, so we need to be flexible, but at the same time, we still need to hold people to the same high standards that they always have been held to, and to continue to do that. Employees need to participate in investigations when asked. And companies need to hold employees responsible for misconduct whether they're working in the office or they're working at home. The government isn't going to give companies a pass for the bad actions of employees just because they might be working at home, whether they're immune compromised or scared to come back to work or anything else. Government's not going to really care too much about that if there's regulatory or legal violations in play. So companies, while needing to be sensitive and strike that balance, they also need to take the same approach that they otherwise would.
Great. Thanks, Matt. Francesca, one thing that we haven't touched on that I think you might be able to help us with is in this environment in conducting the types of remote investigations we're talking about, doing the sort of document collection and accessing that we're talking about. One thing I think we should stay mindful of is how data privacy concerns and regimes like the GDPR are going to be an overlay of this. So do you want to give us your views on how to manage that and what we need to not lose sight of?
Absolutely. So General Data Protection Regulations, GDPR, is a minefield, and sadly we probably don't have time to go into it in detail, but it's something everyone should have in mind. So I'm just going to mention the top 3 things to have in mind from a GDPR point of view when you are evidence gathering. So internal investigations are almost inevitably going to end up dealing with personal data, most commonly employees' data. And in Europe, that's going to trigger obligations for anyone handling that data. So have in mind the GDPR. That's obviously the key piece of law governing data in Europe. But also keep in mind that each European Union member state has transposed the GDPR into their own law with their own legislation. So although the GDPR sits at the top, each state will have slightly different rules. So you're really going to need local law advice if you are operating in any way, gathering evidence or materials or data within Europe. Secondly, have in mind that moving data across borders may not always be lawful. So you're going to, again, quickly need local law advice about the lawfulness, first of all, of seizing that data and then of moving it out of the jurisdiction. If you are in a situation where the data can be seized but not necessarily moved, with all the wonderful technology we have now, there are workarounds around that, which I've used myself in investigations where you can perhaps host the data or an image of that data overseas and then still access it from other jurisdictions. And then finally, just have in mind, this picking up on something someone else said on the panel, that with preservation holds or document retention notices, as we would probably call them here, in some jurisdictions, these really don't mean anything. And actually, you may well need a court order to ensure that parties who have relevant information keep hold of that material and don't dispose of it. So just my top comment really about dealing with data in different jurisdictions. Certainly if there's a European perspective, get local law advice because it really can be very tricky.
Great, thank you. So we're getting close to the end of our time, and we've gotten a couple of questions from the audience. So I want to turn to those and make sure that we get those addressed. I'm just going to open this up for the group. If we have uncovered misconduct that would normally result in termination of employment, are there things we need to consider and handle differently given the pandemic in terms of heightened risk of employment litigation or arguments an underlying investigation was somehow flawed or inadequate? Anybody want to take that up?
Sounds like an. Oh, go ahead, Peter.
Yeah, go ahead, David.
Okay, it sounds like an L&E question. So I guess for me, the one comment I would say is you don't need to terminate an employee to effectively terminate them. So if there's a reason to keep an employee under the control of the employer, you could always put them on an administrative leave, and whether it's paid or unpaid is obviously a function of state law and FLSA. But I think in this dynamic, there may be and probably are additional reasons why, rather than just terminating employment because it's what you would do normally, it makes sense to park an employee, for lack of a better term, so that you can evaluate whether or not there's a need to have them under control, to require them to cooperate in an investigation, to make sure that you get all of the corporate property that they have at their residence back to where it needs to be.
And just to add a little bit to what David said, I think that, this is a real concern that we are seeing from clients with respect to, how do you enforce and hold employees accountable to what they need to do to assist the company through an investigation. Employment litigation sometimes trails developments, and we're starting to see, some of these touch points come into focus in terms of potential litigation risk. I think David makes an excellent point to be mindful of your flexibility in handling and addressing employee concerns. You have flexibility. You want to be consistent, obviously, but if there's a need to put an employee on administrative leave, do that. And also, just quickly, remember to keep in mind accommodation needs that may be necessary, not to take advantage of the process, not to let the tail wag the dog, so to speak, but to make sure you at least go through that. So as I mentioned earlier, the process, the investigation itself can be defended even when you have a reluctant employee or employee who's complaining about mistreatment.
Yeah, and I guess I'll take up, because I do think that question was largely L&E focused, but there was also an aspect of it about criticism that an investigation may have somehow been inadequate or flawed. And I think that there's been a common theme through the discussion here that I think focuses on that portion of the question, which is I think the way that you avoid that criticism of the adequacy of an investigation is it's really about, just like any time we conduct an investigation, it's have we planned it well? Have we executed according to that plan? Have we documented things the right way? So it's just maintaining a focus on those best practices, and in particular, documenting all the ways that the investigation was done in a reasonable and appropriate manner, and including things down to the level of, if you've got a witness that had concerns that we can document, we accommodated their concerns. We made sure they were comfortable with the setting that we were in. If it's a situation where they've got counsel, we had accommodated their counsel. I think, those are, I think it really is, again, another theme that we've had. A lot of this is we're really doing the exact same things that we were doing before. We're just doing them in a slightly different posture. So another question that I think we can squeeze in the last few minutes, how should we handle a situation where a witness refuses to cooperate in an interview unless and until it is in person? What about a situation where a regulator or law enforcement agency is demanding to conduct in-person witness interviews? I guess that assumes that we're in a posture where you're in a state that's reopened, and there's some view that it can be done safely. Molly, Matt, or Francesca, do you guys have any thoughts on that?
I mean, my first thought is generally employees don't get to dictate how an investigation interview takes place, whether it's in person or remote, although this is a unique era, right? But they're typically required to cooperate with the company's internal investigation as a condition of their employment. So in most cases, you should be able to conduct an interview one way or another. As for, I think the second part of that was whether the government's demanding in-person interviews. I think it depends on the facts of the situation. First of all, is the person immune compromised, or do they have some other reason? Maybe it's mental health or another reason why they just absolutely would not be well advised to partake in that interview in person. And then there are the lesser threshold types of cases. But I think the first thing to always do is to just appeal to that government lawyer or that agent's better sense of decency, and also offering an alternative way of conducting it, offering the person for a video interview or over the phone, but that's possibly not going to be what they want. Next best thing, maybe think about getting a doctor's note from the person to provide to the government. So this person, they truly aren't advised. Their doctor says that they shouldn't be able to, be there in person. If necessary, go to the court or to the agency's supervising body. But I think it really is a case by case, fact sensitive basis.
I would agree with Matt on that. And I would also say in considering alternatives, and especially when you're dealing with government, try to think of alternatives. I know of one instance where defense counsel worked out an attorney proffer in lieu of an interview. And again, it was done virtually, but ended up actually giving the government more useful information, I think, than in a situation where the government would have interviewed the witness. So again, I completely agree with Matt. This is a time where we all have to be flexible and really ferret out what are real concerns and where are folks gaming the system, and try to think outside the box and figure the best way forward.
I would echo what Matt and Molly have said, and just add to that here in London there were a lot of difficulties at the outset with interviews and law enforcement who were not willing to compromise. But then what happened was that the London Defence Solicitors Association really pulled together to open a dialogue with a police body, and they were able to work out practical guidelines that were flexible enough to allow for individual situations, but started as a general premise and framework to enable conversation. And that's worked really, really well here at just finding practical solutions and a way through.
Great, thank you. Well, we have hit the top of the hour, so I want to be mindful of everyone's time. Thanks to all of you who have joined us for this panel discussion. Thanks in particular to all the panelists. Really enjoyed the conversation, and we appreciate your participation, both attendees and presenters. So with that, thanks everyone. Have a great rest of your week.